the family not made aware of his whereabouts. And why was he not arraigned in court as per the Article 49F, which talks clearly on the procedures on how to deal with an accused person. Therefore, it is my humble submission that the prosecution have not proven to come with clean hands, like I said. It took them from the time they arrested the accused person to today at 5:20 to come up with this affidavit that is full of assumptions, innuendos, and presumptions. If you look at the affidavit,
Your Honor, just for guidance, I don't like it. I just Owino'S director indicated that it should have been done by 6, so the prosecution ended up being curtailed. So just be direct whether there's a real way this as she said, equity still comes to
equity must come with clean hands.
even as we require equity.
Yes. You can seek for us to reply.
Yes.
Everything that is being said is on record, so you not
Yes.
what another council has been saying.
Okay. Much obliged to your Honor. So, in parting short, my humble submission to this honorable court is that the accused persons are not at flight risk, and that the affidavit presented before this honorable court does not prove or necessitate reasons why they should be denied bail, and therefore I request this honorable court to protect, uphold, and safeguard the 2010 Constitution. Thank you, Your Honor. I would like to call my senior, Owino'S, to order.
Yes, Your Honor. Thank you so much. I will not take too much of your time, Your Honor. I appreciate that you have spent so much of your time already for the day. Except that what is before you, Your Honor, is a very fundamental issue that goes to the heart of rights that are guaranteed and protected under the Constitution of Kenya and under the Bill of Rights, no less. That bill, Your Honor will appreciate, is not just an ordinary chapter in the Constitution. It essentially is the heart of this Constitution. You violate any of the provisions of that chapter, you essentially snuff out the life of this Constitution for all we know it to be. And I say that, Your Honor, with great respect, because as a practitioner, as an officer of this court, which I believe Your Honor has been before ascending to this very hallowed position in the judiciary, we have a duty, Your Honor, to enforce and uphold and defend this Constitution. And in the course of doing so, particularly with the division of labor within our courts of law, as you deal with these questions every other day, Your Honor, sometimes the detail of it and the weight and significance of some of the provisions of this Constitution will be lost. And most of the time, inadvertently. And I say that, Your Honor, because it is now becoming a norm that the agencies that have been created under this very Constitution, sorry, and under the terms and conditions enshrined in this Constitution, are now repeatedly and so brazenly violating cardinal rules they are repeatedly, Your Honor, and so brazenly violating cardinal provisions of this Constitution that we as a people agreed will determine the relationship between those whom or to whom we delegate authority to exercise on our behalf, and us or we the people, and between those agencies intersect. They are violating the common law. And that is very critical and important, Your Honor. It is critical because as I started my submission, this Constitution is the lifeline of the existence of this country as a nation state. You snuff life out of this Constitution and you invite chaos and anarchy in the manner in which we coexist. And so the violation of this Constitution, particularly by those to whom we delegate authority, cannot, and my lord, cannot, this must be taken very seriously, cannot be taken lightly. And that is why I said, as I started, Your Honor, and I said it with utmost humility, that in the course of our ordinary practice, particularly before these specialized divisions of the court, it is very easy to lose the detail, the weight, the significance the nuances, the detail, the significance, the nuances of some of the provisions of this Constitution as we intended them to operate. So that, Your Honor, it has now become a very sickening trend that police officers, despite express mandatory provisions of this Constitution that prescribe the holding of detainees for more than 24 hours without compelling reasons, will very comfortably appear before you hours after they have violated a mandatory provisions of the Constitution and present an accused person before you, and then without batting an eyelid, ask you for permission to hold them for even a longer period of time. Your brother, the Chief Justice Emeritus William Mutula, coined it very interesting. The Utadu attitude. That an agency created under this Constitution, exercising powers under this Constitution, presumed to be aware of the proscriptions and the prescriptions of this Constitution, can violate it and then come before you and ask you to perpetuate that violation by granting them more time to hold accused persons for an even longer period of time. Your Honor, before you are just these two documents. Your Honor, there's a charge sheet and there's an application to hold these accused persons for a further period of time, and specified time for that matter. You can see the mischief. They're even asking you to just grant indefinite leave for them to hold these accused persons for an indefinite period of time. And Your Honor, just scan through this document. Not a single explanation has been attempted for why these gentlemen are being brought before you more than 24 hours after they were arrested. The Inspector General of Police has not bothered to provide the Director of Public Prosecution with any reasonable explanation, or any explanation for that matter, why these gentlemen were held for that long, and the Director of Public Prosecutions, who under this Constitution is supposed to exercise
Yes, Joe. How many more minutes?
Your Honor, can I take just 10 more, please? Well, Your Honor, at the heart of these submissions before you is a freedom of gentlemen here who have been held incommunicado for more than 24 hours. I think they deserve just that extra 10 minutes. Your Honor, the Director of Public Prosecutions, an office created under this Constitution, who is supposed to exercise independent oversight, as a countervailing measure deliberately created by this Constitution, has approved a charge sheet also granted. Yes, has approved a charge sheet, Your Honor, which does not, in fact, has not only approved a charge sheet, has actually caused to be drawn an application to detain the accused persons and therefore perpetuates the Constitution without even bothering to inquire from these accused persons who are arrested. Why have you been holding them incommunicado for more than 24 hours? And that points to another lapse in the respect for and enforcement of the Constitution of Kenya, which I have in my remarks earlier said pose grave danger to our continued existence as a rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger that is a danger the common bond that I alluded to, that this court must guard against. And my lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused person. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Miss Asha Bashir, has submitted to you that he who comes to equity must come with criminals. The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day longer? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, the law on bail and bond applications is fairly well settled, and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents. Most of that.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30.
You know, we started at up to 4 in the morning.
Let me finish. So we are going to start at this point. Tell us some issues that are related because we will not be.
Secondly, Your Honor, they are members of our Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
You know, with all due respect.
Then I have to have your Say 5 minutes, I've only 2 minutes. Your Honor, this affidavit has no date. That's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice that the same police officers who saw this affidavit came to court and said they were forced.
So your objection that line with respect.
That is judicial notice of it.
The officer that did phone to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about
passion for STEM. Studying science, technology, engineering and maths can be tough. So ICRGU are launching our ICRGU STEM Academy. We're going to be offering free online resources from quizzes and webinars to science experiments for you to access